well, well versed, well versed professionals. We know this insolvency law is based upon the BLRC report, Bankruptcy Law Committee report. This report basically the committee was constituted by an order of the central government in November 2014, which gave its report in November 2015, basis which this law was enacted. The objective of insolvency law was to maximize the value of assets and, most importantly, ensuring the equitable treatment of similarly situated creditors, provision of timely, efficient, and impartial resolution of insolvency, and the most important objective of the law was time is the essence of process. So CIRP initially it was said that it will be completed within a period of 6 months, from 180 within 180 days. Then there may be an extension of 90 days to 270 days. Then there was an amendment which came that all this has to be completed within 330 days. However, the Supreme Court in SR case, it says that the time limit are discretionary, it cannot be mandatory time limit so far as it is in relation to the completion of the process. Now, since we are mainly dealing with the rights of the creditors and how it is dealt in the IBC, we are more focused on the basically interplay between the financial creditors, the statutory bodies who have stakes in the resolution plans and the CIRP process. Then there are operational creditors, there are MSMEs. So first of all, if we may recall, initially the home buyers were not considered even a creditor in the CIRP. Initial law had not recognized them as a creditor. The first case which went to the Supreme Court was Chitra Sharma versus Union of India. And this has a relationship with the CIRP of JP Infratech. JP Infratech was the first case of the home buyers which went to the Supreme Court, and the Chitra Sharma, under the provisions of Article 32 of the Constitution, they said that the rights of the home buyers have not been considered under the provisions of the insolvency law. Court directed the central government to come up with some sort of regulation and made some amendment. Initially, Form FA, categorizing the home buyers as other creditors, was introduced. Initially, I think it was in December or January 2018. And after that, on 6th June 2018, the law was amended through an ordinance, and the home buyers were given a recognition of the financial creditors.
Sorry, sir, interrupt you in between. ये जो है ना डिस्प्ले आप कुछ दिखाना चाहते हैं, क्योंकि ये जो है ना स्क्रीन पे एक डिस्प्ले दिख रहा है. If you want to show something, then otherwise इसको हटा दीजिए प्लीज. Okay. या आप यहाँ डिस्प्ले हो रहा है?
हाँ, नहीं हो रहा है.
तो यहाँ हमें नहीं दिख रहा है सर. अगर कुछ if you want to show something,
ये अब स्लाइड आपको शो नहीं हो रही है?
जी नहीं, स्लाइड शो नहीं हो रही सर.
हम तो यहाँ शेयर किया है हमने. जस्ट ए मिनट, लेट मी डू अगेन.
जी सर, प्लीज. जो इवोल्यूशन आप आईबीसी का जो स्लाइड है उस पर डबल क्लिक नहीं है.
एक मिनट, मैं यहाँ से करता हूँ. आपका ये साइड कहाँ है? Just a minute, sir.
प्लीज।
आपका ये सिस्टम
आप शेयर कर पा रहे हैं ना? शेयरिंग अलाउड है ना आपको?
हाँ हाँ, शेयरिंग अलाउड होनी चाहिए हमारे समझ से तो न्यूज।
Yes, sir. Sharing is allowed.
Now it is appearing or not?
नो सर, नॉट। वहां डबल क्लिक कीजिए ना, जहाँ इवोल्यूशन ऑफ आईबीसी कर रहा है, वहां डबल क्लिक।
डबल क्लिक ही किया है मैंने तो।
क्लिक तो नहीं रहा सर, ओपन नहीं हुआ।
हमारे हाथ ओपन हो रहा है। नाउ
नहीं सर।
दोबारा ज्वाइन करूं?
इसको जो है ना, जो स्लाइड शो हो रहा है उसको पहले बंद कर दीजिए, कट करके प्रेस शेयर पे जाइए।
से कर रहे हैं। अब आया?
नहीं
अभी
आया।
नहीं
हाँ, हाँ।
चाहिए था। एक मिनट बंद कर।
इसको बंद कर दीजिए एक बार। हाँ, आप शेयर कीजिए सर।
स्क्रीन शेयर हो रहा है?
जूम तो दिख रहा सर जी, शेयर हो रहा है जी सर।
Yes, sir. Yes, sir. तो तू यहाँ कर क्या रहा है?
Yes sir, now it is okay. Please sir, please.
So we were discussing Chitra Sharma case. Now it is clear.
Yes sir, please go ahead.
So Chitra Sharma was related with the insolvency of JP Infratech. JP Infratech, this Chitra Sharma and others, they went to the Supreme Court, and Supreme Court directed the government of India to basically consider the home buyers case. And consequently, they were recognized as financial creditors, and they were made part of the CRP process. They were made basically the members of the committee of creditors, and the right to vote were given after this judgment. Prior to that, there was no right to the home buyers to participate in the CIRP, and basically they were not recognized as creditor. So next case which came for consideration was Swiss Ribbon Private Limited. Swiss Ribbon Private Limited versus Union of India. This is basically one of the most important case in the history of insolvency law. Here, the entire IBC was challenged. The constitutional validity of the various provisions of the insolvency law was challenged before the Supreme Court, and also the differentiation between the operational creditor and the financial creditors were under challenged. Then there was a challenge of section 29A, there was challenge of basically the functioning of NCLT and NCLAT, the appointments of members and all. The court, having considered the entire government of law and every aspect of the insolvency law, come to the conclusion that classification between the financial creditor and operational creditors are neither discriminatory nor violative of Article 14 of the Constitution. Meaning thereby, they recognize the differentiation between the operational creditor and financial creditor at the first hand, and constitution of COC only with the financial creditors at the other hand are valid, and Supreme Court upheld the provisions of insolvency code so far as the treatment of operational and financial creditors. And the argument which was placed before the Supreme Court, which was considered and upheld by the Supreme Court, is that the financial creditors are more knowledgeable, they have appetite, they have a strength to basically assess the viability of the corporate debtors, and they have basically access to the information. They can check the viability, they assess the feasibility of the resolution plan, and they are more into the business of financing, so that they have more knowledge, and they will be basically they will be ready to restructure their debt as against the objective of the operational creditor to realize their own money, which is against the supplies of service or basically the goods. The Supreme Court upheld the division, and it upheld that the COC should be constituted by the financial creditors. Then the next point which came, there was an amendment made in 2019. Regulation 38 was amended, the CIRP regulation 38, to say that operational creditor will be provided, basically operational creditor will be given priority over other payment after the CIRP cost. But in my view, the fact is that the operational creditor till date have not been able to get anything out of the CIRP. Law says that they will be given priority, and what they can get at the time of liquidation should be paid. At the practical situation is that whenever there is an insolvency, the operational creditors are at a loss. They do not get anything. And this is a fact. This is a fact. Law says there should be a fair, just, and equitable treatment. They should be given priority. But the fact remains that the liquidation value in terms of the operational creditor is more or less always it is zero, and they do not get anything. Even if they trigger the insolvency, the application which is filed under Section 9 by the operational creditor, in that case also they sit outside the committee of creditor. They don't have any right to negotiate, and they do not get anything. That's the basically practical aspect. The law says that they should be provided priority, but actually they do not get anything. Then in case of a COC of SR Steel Limited, for Satish Kumar Gupta, the question which arises was, can there be a differentiation between the creditors in terms of the payment? The resolution plan said that the operational creditor will not get anything. If they have a claim of more than 1 crore, they will get around 5%, 10% if they have a claim of more than 1 crore. And then the unsecured financial creditor were treated differently than the secured financial creditor. The matter went to the NCLAT. NCLAT reversed the, basically they gave directions that everybody should be given at least 60% of the claim value, including the operational creditors. The matter went to the Supreme Court in this case, and the Supreme Court said that treating equally does not mean that all the creditors will be treated equally. Treating equally means same treatment between the class of the creditor. So the financial creditor who is secured should be treated equally. The operational creditors, they are situated similarly, should be treated equally. So there can be a differentiation between the operational creditors and the financial creditors, and basis that this case become a landmark in terms of the rights of the operational creditors and the financial creditors. So far as the case of MSME, in my view, MSMEs are protected by a law which is altogether a different law, MSME Development Act 2006, which cannot be said that it is basically contradictory to IBC, because it is a beneficial legislation which has been specifically enacted, and provision of section 30 clause 2 clearly states that resolution plans should comply with all other laws. So if that is the case, can right of an MSME who is an operational creditor be deprived? But this is an unexplored area, and it has not been basically come up specifically before the Supreme Court as of now. And there is no such judgment. How should they be dealt? Operational creditor, it is always said that they are not secured, and they don't have, basically they will be treated as per the regulation 38, which is amended 2019. And it says that they will be given priority, just an equitable treatment, but the fact is they are not getting anything. So SR case, the differentiation in terms of the payment to the operational creditor and the financial creditor, secured creditor, unsecured creditors, it was upheld by the Supreme Court. Now, Pioneer Land Infrastructure Limited versus Union of India, this was also in relation to the basically right of the home buyers, and they were upheld to be treated as a financial creditor. The question which arises before the court is, what will be the situation if the home buyers have borrowed money and then invested in a company for allotment of the flats and all? So can the banker or the financial institution who have given loan to the home buyers should be part of the COC, or the home buyers directly should be part of the COC? So basis the report of Insolvency Law Committee, where Mr. Sardul Sarraf, who has given a dissenting view saying that the financial institution should be part of the COC, the court held that it is the home buyer who have been recognized as a financial creditor, whether he has borrowed money from some financial institution or the bank, or who have basically invested from his own coffer. So the court was very categorical that it is the home buyers, they should be forming part of the COC. It cannot be the bank or any other institution claiming through home buyers. In one of my case where I was RP, Axis Bank filed a claim of around 48 crores for financing different home buyers. I had rejected their claim. It went to NCLT. NCLT accepted my version. Then it went to the NCLAT. NCLAT also basically relied upon this pioneer urban land development case and said that the Axis Bank does not have any right. They can only go against the home buyers, or if the property is handed over to them, the home buyers, if it is registered in the name of the home buyers, if they got the possession of the property, it will be mortgaged to the bank, and that the bank can proceed as per law, which is at the agreement which they have signed in between. So basically, they have no right to interfere in the ARP if they have provided loan to the home buyers. They will not be recognized as financial creditor because there is no privy of contract between the corporate debtor and the banker. They have provided loan to the home buyer. Home buyer has invested the money. So their right to recovery lies against the home buyers only, not against the company. So this is an important case which was discussed. Then this case, this is basically a shift from the entire basically argument till 2021. As we all know, as per the provisions of 53 and all the treatments, the statutory dues under waterfall mechanism comes at a fifth stage. First is ARP cost, liquidation cost, and then the workmen, and then employees, and then secured creditors, and then unsecured financial creditor, and after that the government dues, the GST, everything was there. But this case changed the entire scenario. State tax officer versus Rainbow Paper Mills. The court held that as per the statutory provisions under the VAT Act of Gujarat, and there are similar provisions in all the VAT Acts, there are similar provisions in income tax, GST, even ESI, even PF, everywhere there is a statutory charge against the asset, first charge against the assets of the corporate debtor. The court recognized in this case that by the virtue of operation of law, these statutory authorities have first charge over the properties, so they will be treated as secured creditor. They did not say that they are secured financial creditor, but they will be treated as secured creditor having first charge over the asset. So actually by implication of this judgment, all these statutory dues become at par with the payment of dues of workmen, bypassing the waterfall mechanism and everything. In Paschimachal Vidyut Vitaran Nigam Limited versus Raman Ispat Private Limited, this judgment, Paschimachal Vidyut, was passed after state tax officer's case, and this was under liquidation case. Court took a contradictory view, the Supreme Court, and said that the judgment passed in state tax officer versus Rainbow Papers was at a different basically perspective, and it should not be a law of land. But interestingly, when the review petition was filed in a state tax officer case, on the basis of Paschimachal judgment, the court dismissed the review petition. Then the law laid down in a state tax officer versus Rainbow Papers became absolute. And the agencies, as of now, all these statutory agencies, they are claiming that they are secured creditor and they should be paid as a first charge holder, as above the secured creditors, as the financial creditors, and all others. So they should be paid all the statutory dues, including the income tax, GST, VAT, everything. They should be paid on priority under the resolution plan. So this is basically a shifting from the earlier jurisprudence where it said that the statutory dues will be considered as operational creditors. All the government dues will be considered as operational creditor. There are judgments of Supreme Court and CLAT everywhere. They were and under the law also it says that they are at 5th position under 53. But this judgment other way around recognize that they are secured creditor by the virtue of law and they will be basically considered as such.
Sir, in this case, then the financial institutions who have paid that amount, that will be considered as later on after the deducting the statutory dues.
Yes, see, all the resolution plans, they have to basically consider this, which is all, see, all which have already been implemented, we cannot go and undo it. But after passing of this judgment, NCLT, NCLAT are now insisting upon the resolution applicant to provide for payment of all these statutory dues prior to any other payment.
Means prior to the bankers.
Yes, prior to the bankers. Prior to the bankers, because they have a first charge over the asset. And bankers' charge is by way of contract.
Yes, sir.
And
yes.
this is by virtue of law.
And this is a very landmark judgment.
Yes. And they have changed the entire process. Basically, they unsettled the entire jurisprudence. It has changed the entire jurisprudence.
Yes, sir.
After that, Damodar Valley Corporation. This is an NCLAT judgment. Basically, Justice Ashok Bhushan. He observed that as per law, the operational creditors are not basically getting anything as of now. And the time has now come that the government should rethink about the treatment of operational creditors. However, the time has come when it should be examined by the government and the board means IBBI, to find out as to whether there are any ground for considering change in the legislative scheme towards the payment to the operational creditor, which also consists of the government dues and other statutory dues. So statutory dues, government dues, now they have been taken care by the judgment of Indira Banerjee in this state tax officer case. But the operational creditors, as on date, they are the most deprived class of creditors in terms of the CIR. They don't have any say in the process. They do not form part of the CIRP. They are not even member of the COC. The only exception is that if the claim amount is more than 10%, they may participate in COC meeting, but without vote, and they cannot say anything. They cannot object. So they have no right to negotiate with the RA, the resolution applicant, and they are not getting anything. The NCLAT recognized the problem and asked the government to reconsider the provisions insofar as the operational creditors are concerned. But till date, I don't think there is any proposal by the government to consider it.
Sorry for interruption, sir. May I interrupt in between? Otherwise,
yes, no problems.
So because once there is a 10% or more than 100 allottees are there, then they are considered as the financial creditor.
Allotment is different. They are not a personal creditor. That is financial creditor, home buyers case.
Yes.
So they are home buyers. Here, for participation in COC, the operational creditors will get a notice if they have a claim of 10% of the total claim. So somebody will represent them in the COC, but they will not have right to vote. Like the members of the suspended board, they will be attending the meeting, but they cannot negotiate, they cannot vote. So if they have no right to vote, even if they have more than 10%, so they cannot do actually anything.
10% of what? They are more
10% of the total claims received.
Okay, if the operational creditors is more than 10% of the total claim received,
they may have a right to participate, but
yes,
right to participate without vote will have no bearing.
No bearing. No.
And ultimately, the law says that they will get what they can get at the time of liquidation. And the actual position is that when the insolvency commences, the asset erosion is such a situation where it is not sufficient to meet the financial creditors' need. So either the distribution of assets should be proportionate to the debt, or there should be some other mechanism.
Yes.
Because the objective is to rehabilitate the corporate debt. It is not, see, what was the objective? It did not say that it is the law says it is not a recovery proceeding.
Yes, of course.
Then but ho kya raha hai? Actually, what is happening? It is only a recovery proceeding, and that is tilted in favor of the financial creditor.
Yes.
Because if you consider the operational creditors are basically the suppliers of goods and services, they are scattered, they don't have means to basically sustain if their payment is not ensured to be made. And in the long run, the IBC would become counterproductive. Because operational creditors, if they are not being paid, so their payment is gone.
Yes.
So there will be an issue of sustainability. And in case they have taken loan from the bankers and others, they are likely to be a defaulter because they will not be able to pay. So ultimately, the objective of this IBC, which was to rehabilitate the corporate debtor and to make equitable treatment to the creditor, is, in my view, misplaced.
Please, sir. Rightly said.
It has not been basic. Either you make some see, at the time of liquidation, there can be some yardstick. If you are continuing with the process, if you are continuing with the company, and then there is a resolution plan which is coming, then operational creditor must get something. Otherwise, who will supply? And why there will be a supply chain? Everybody will say that, no, you pay me in advance, then I will supply, otherwise I am not interested in making any supply. Then what will be the situation? But so far as the journey of this insolvency law, the 7-8 years, it has only helped the financial creditor recovering their money, and that too not in a good portion, 30%, 40% or so.
Even the financial creditors are also not getting 100%.
Oh, no, they are not getting full amount recovery. But see, if they are getting, and who is at a fault? You have basically financed, and you had an obligation to monitor that the money is being utilized for the business, but you did not do that. The stock statement and all these things were manipulated. You were kept your eye closed because you say that You feel that I am secured, I will recover. And you, due to your inability to monitor the end use of the fund, the money was diverted, and ultimately it is the loss of the operational creditor, not the financial creditor, because you are secured, you are recovering it, and the operational creditor are basically deprived of all these things. So law is, in my view, not protecting the right of the operational creditors.
Right. Thank you.
And this was recognized by NCLAT, Justice Ashok Bhushan in this case, Damodar Valley Corporation, Versatile and Steel. And they recommended, and the copy of this order was marked to the ministry, that you should now, the time has come to reconsider the entire system of repayment. But the government has not paid any heed on this. And they have not done anything. This is another dimension. Lakshmipat Surana versus Union of India. This has basically relation with the liability of principal borrower and the guarantor. Initially, it was said that insolvency can be commenced only against the principal borrower. Then it was said that no, it can be against the financial, basically principal borrower and the guarantor also, because section 128 of the Contract Act, both are simultaneously liable to repay the debt. And if there is a process against the basically principal borrower and also the guarantor, can the creditor, who is the lender, file their claim in both the cases? And what will be the amount of claim in all the cases? Can it be 100%? Can it be 50% in this case and 50% in other case? How will it be basically dealt? So this judgment, Lakshmipat Surana versus Union of India, it says that the right of the lender is primary and it can be exercised against any of them, both of them. And it is based upon the Insolvency Law Committee report of February 2020, we say that the creditor is at liberty to proceed against either the debtor alone or the surety alone, or jointly against both the debtor and the surety. And this proposition of law was recognized as Lakshmipat Surana. And it was
law basically says, once the person who was lending the money, once they are able to recover the amount from the borrower itself, then there is no role of the guarantor. Because
no, if you are able to recover, then it's fine. But if it is not recovered and process is triggered against both,
but how do you come to know if it has been recovered or not recovered? Because
no, the creditor has to file a claim. Creditor has to state at the time of filing of the form of claim, form C. If you see the form C now, it has now been amended. The form which the financial creditor has to file at the time of submission of the claim, it says that if there is a surety, yes, whether there is another process going on or not, have you recovered anything or not from there. So if you are not getting anything from other, you can file claim of 100% of your amount at both the process, that is against the borrower and the corporate debtor, the principal borrower and the guarantor. And in case you get some recovery from one place, you have to intimate it to the other resolution professional that I have 100 crores of loan, I have recovered 20 crores from A, and now I have outstanding of 80 crores against B.
Right.
But the process can go on simultaneously against the lender and the borrower, and it is the mandate of section 63 of insolvency law, IBC. 63 said, section 60 subsection 3, it says that where there is insolvency against the corporate debtor, there can be insolvency against the guarantor also, and it will be basically dealt by the same bench, NCLT.
Means once you are filing an application under section 7, then you can make a party simultaneously to all borrower.
No. You cannot. You have to separately file application against the guarantor also.
Okay, not in simultaneously. Make a party to the all borrower.
No, you cannot. You cannot. That is not allowed.
Oh.
You have to come up. Basically, there are different sections to deal. So 7 is against the corporate debtor. If there is a corporate guarantor, you can file a section 7 against them directly. If it is a personal guarantor, you can file section 94, 95 application.
Fine, sir. Thank you.
So on the basis of guarantee, you can trigger the insolvency, but that is to be filed separately. So now this is another dimension. Greater Noida Authority versus Prabhjit Singh Soni. Here what had happened, there was a land of Greater Noida Authority upon which the housing project was going on. The authority filed belated claim. The claim was not considered, and the resolution plan was passed, stating that the Greater Noida Authority will not get anything. So authority will have no right to recover anything. And the land belongs to authority because they are the owner. The corporator is only having right of lease as a lessee, the leasehold right. So the entire Greater Noida, or any other authority for that matter, development authority, DDA, or all other authorities where the lands are allotted for development, housing development and all. The lessee gets leasehold rights. The property belongs to the original owner. In this case, the Greater Noida Authority, they challenged the resolution plan before NCLAT. NCLAT did not hear them. They went to Supreme Court. Supreme Court says, how can you not make payment to the owner of the land and you can use that land? How come there be a resolution plan? If the property is not of the corporate debtor, how will you get a right against that property unless you pay the lease rental? So in this case, and this is a February judgment, February 2024, by the Chief Justice bench, Dr. Chandrachud.
Very latest judgment.
February 2024 का. And the court said, so you have to make the entire payment of the lease rentals to claim leasehold rights. Otherwise, there is no land.
Because Greater Noida Authority has also
so Greater Noida Authority and all other authorities, the Bombay Authority, there was another case in Bombay Authority and then the Noida Authority, they have now been 100% secured.
Otherwise, it was treated as operational creditor.
They were treated as operational creditor. So the effect which is coming, initially they were considered as operational creditor. They will not be provided anything. Then there was a shift in state tax officers versus rainbow papers, where it is said that by virtue of operation of law, there can be a security interest. And this finally, Greater Noida Authority, it says that The authority is the owner of the property. You are only a leasehold right holder. You cannot claim the right on that property, and RA does not have anything unless it pays the entire lease rentals. So lease rental is as equivalent as to the market value of the land. So you have to pay 100%.
All of their judgments are very interesting judgments.
So that is why. And now this is for basically our basic thought of today. What should be, whether, see, 29A provides, section 29A provides that in case the corporate debtor against whom the insolvency has triggered is MSME, they will have some protection. And the management can participate in providing a resolution plan. They can bring a resolution plan because no other party would be interested in investing money in the MSME. So the rule is management will not participate for submission of resolution plan, against which there is an exception for MSME. But similar exception has not been provided to the creditor of MSME group. So if a creditor is MSME, they are supplying, but their right is not being protected. If the debtor is MSME, you are providing some relief, you are giving them a status that the management can file resolution plan, they can participate in the process of insolvency, and they can keep the company against the settlement. But if the creditor, who are operational creditor, who are registered as MSME, who have supplied materials or services, they don't have any protection till date. So my question is whether this 29A is violating against the MSME creditors.
Yes, sir, probably yes, because protection is given to the debtors.
Then why not to the creditors?
Why not to the creditors? Because mostly in the IBC, protection are given to the creditors.
But it is other way around.
It is other way around.
And now at question number 2. This is an amendment which has been made in September 2023. And most probably it is based upon a judgment in Puneet Kaur versus KB Developers, where it has been said this new regulation 13A has been inserted. And it is stated that if you are filing a belated claim, the COC will decide how to deal with your claim. Inherently, the claim has to be decided by a resolution professional. And if the claim is accepted, and if it is a financial creditor or the home buyer, they have to be made part of the COC. But this regulation is saying that it will be decided by the COC how to deal with this claim in the resolution plan. Means they will not be form part of the COC, or whether they will be forming part of the COC, what will be the fate, what will be the determination, how much payment will be made to them if they have filed a belated claim. All these things went into the hand of COC only by insertion of this clause 13A with effect of September 2023. Now, the question is, if there is no such provision under IBC to deal a creditor differently, whether this regulation violates IBC and the Constitution.
Probably yes.
How can you see? COC will never like to include anyone
Yes, yes, of
who
course.
has come at a later stage or make any payment to them, because they will feel that it is my share which is going to them.
To someone else, of course, of course.
So how can you give a right to them? And that too against the mandate of the IBC. IBC has never said such an adjustment. If you are introducing something new by way of regulation, can it sustain the scrutiny of law?
Sir, what
Because
is the
the
law?
law has to be amended by the parliament.
Yes, sir.
The substantial provisions of IBC must be amended by the parliament.
Yes.
If you are making such regulation which directly affects the right of the creditors, otherwise than the mandate of the IBC, can this regulation sustain? So these are the cases.
Controversy will arise, then the law, and anyone will file an application, and then
but till date it is not there. It has not been basically challenged or has not been adjudicated upon.
So basically, I would like to know, suppose if it is the last date for filing of the claim on 18th June, and we have filed our claim on, suppose, 21st June. It is the discretionary power vested with the IRP that whether he can admit.
See, 90 days, there is no problem. Then after that, it says that till the approval of resolution plan, if you were filing, 7 days prior to the approval of resolution plan, you were filing, then he has, the RP has to include it. And now also, the amended provision of CIRP regulation, it says that RP has to make estimation of future claims on the basis of the books of accounts available with him. But the fact is, in 90% of the cases, the books of accounts are not handed over to the RP, or it is not updated.
Till the books of the accounts has been handed over to the RP, till that date we can file our claim.
You can file your claim at any stage, but how will it will be treated is the question here. If you are filing at a belated stage, it is the COC who will decide your fate. And that is against the mandate of law.
It is not discussion vested with the IRP that whether he wants to admit it or deny it.
That is what this amendment says.
Okay.
RP has to make basically details of all these claims which have been received at a belated stage, submit before the COC, and the COC will decide how to deal with it.
All the powers are now vested with the COC.
COC. No, COC will not never like to admit any claim or give them any share.
Belated claim.
It runs counter to the mandate of IBC.
Yes, yes. Sir, we got a very valuable knowledge, especially what were the judgments you share with us. Really, that is wonderful. Any one of our friends have some questions? Then Sanjay sir is very having depth knowledge of the subject matter. Please.
The voice is not audible.
सर ये जो है ना PPT अब हटा दीजिए सर अगर then my learned friends want to ask certain questions.
हाँ जी बताइए.
अभी सुधीर
आपकी
सर अभी
आवाज
भी
नहीं आ रही है।
आपका सर अभी डेस्कटॉप पे अभी दिखा रहा है, ये पूरा हटा नहीं। हाँ वहां से कट कर दो, और कट कर दो, एक बार और कट कर दो।
ये बंद करिए।
आपका डेस्कटॉप डिस्प्ले हो रहा है सर।
कर रहा हूँ।
हाँ जी, आप कोई सवाल पूछना चाहें? सुधीर जी कुछ पूछ रहे हैं आप?
हाँ, yeah, my query was, there were incidents which they
आवाज नहीं आ रही है सर आपकी।
सर आपकी आवाज नहीं आ रही, कहीं अगर आप ट्रेवल कर रहे हैं तो रुक जाइए, फिर पूछ लीजिए, फिर ट्रेवल कीजिए।
अभी आवाज आ रही है?
जी थोड़ा थोड़ा
हाँ बोलिए बोलिए बोलिए।
ओके, मेरा query ये था कि अभी कोई recent judgment है सुप्रीम कोर्ट का, जिसमें जो ये कहा गया है कि अगर कोई he cannot be excluded, so even if he has not filed a claim, so I'm just reiterating what Nitya has just said.
हाँ वो
कि अगर
मैंने
कोई
आपको
वो
बताया, मैंने क्या बताया आपको, केवी डेवलपर्स, पुनीत कौर वर्सेस केवी डेवलपर्स में ये बात कही गई कि अगर आपने क्लेम नहीं फाइल किया गया है और आपका लायबिलिटी इज अपीयरिंग इन द बुक्स ऑफ अकाउंट्स, then RP is supposed to consider that amount as a future claim. But in practice आप ये अगर देखिए तो 99% केस में तो बुक्स ऑफ अकाउंट्स आरपी के पास होती नहीं है, हैंडओवर नहीं होती। प्लस अगर हैंडओवर होती है, अगर वो उसकी ऑथेंटिसिटी कितनी है, आपके क्लेम को उसने कंसिडर किया है कि नहीं किया है, उसको एंट्री प्रॉपरली हुई है कि नहीं हुई है बुक्स में, दैट विल बी ए क्वेश्चन। कह तो दिया कि बुक्स ऑफ अकाउंट्स के बेसिस पे करो, बुक्स ऑफ अकाउंट्स होना चाहिए ना करने के लिए।
तो क्या इसमें क्या वो है, मतलब व्हाट इज द वे आउट?
So see, way out is you have to file your claim on time.
But let's say we have a illiterate buyer, he doesn't understand the thing, मतलब आपने नोटिफिकेशन निकाला, अगर
नहीं,
illiterate को
अभी
पता ही नहीं
क्या
आता।
हुआ है उसमें, एक अमेंडमेंट और हुआ है कि ऑन द बेसिस ऑफ द बुक्स ऑफ अकाउंट्स एंड द रिकॉर्ड्स अवेलेबल, द आरपी इज नाउ मैंडेटेड टू सेंड नोटिसेस टू ऑल द क्रेडिटर्स इनवाइटिंग देयर क्लेम्स इंडिविजुअली। तो अगर आपके कॉर्पोरेटर के पास आपका रिकॉर्ड है, आपका ईमेल आईडी है, आपका फोन नंबर है, then the RP is now obligated to send you a specific mail stating that you file your claim.
That is provided the records are updated.
नहीं, पहले क्या होता था कि केवल पब्लिक नोटिस के अलावा कोई भी मैकेनिज्म की बात नहीं थी इंसॉल्वेंसी लॉ में। हमने पब्लिक नोटिस कर दिया, आप आए तो आए, नहीं आए तो नहीं आए। तो उसमें पुनीत कौर की जजमेंट में ये बात जरूर कही गई है कि बेसिस द बुक्स ऑफ अकाउंट्स द क्लेम हैज टू बी वेरीफाइड, बेसिकली कंसीडर्ड एज ए फ्यूचर क्लेम्स। बट वो बुक्स ऑफ अकाउंट्स तो प्रैक्टिकली हम लोग जो यहाँ बैठ के बात कर रहे हैं, वी आर आल्सो डीलिंग विद द प्रैक्टिकल एस्पेक्ट ऑफ द प्रोसेस। तो प्रैक्टिकली लॉ में तो ये लिख दिया गया या कोर्ट ने कह दिया, पर वो एक्चुअली बुक्स ऑफ अकाउंट्स उसको हैंडओवर हुई है कि नहीं आरपी के पास, और वो बुक्स ऑफ अकाउंट ऑथेंटिक है कि नहीं है।
पर इसमें बड़ा इंटरेस्टिंग लगे, मेरे पास क्वेरी आया था। क्वेरी ये था कि जैसे
आवाज क्लियर नहीं आ रही है।
तो मैं बड़ा जोर बोल रहा हूँ, बाइक से बड़ा हाईवे, तो दैट कुड बी द रीजन, मे बी द कवरेज इज बैड।
आवाज नहीं क्लियर आ रही है नित्यानंद जी।
मैं चैट पे डालता हूँ, आई थिंक दैट
आप
वुड बी बेटर।
डाल दीजिए, या आपकी कोई स्पेसिफिक क्वेरी होगी तो आप मेरे से वो कर लीजिएगा,
ठीक है,
नित्यानंद जी को भेज दीजिएगा, मैं आपको बता दूंगा
हाँ जी
जो भी
हाँ जी हाँ जी, श्योर, राइट सर, थैंक यू।
थैंक यू सर, थैंक यू।
थैंक यू।
एनी वन ऑफ यू वांट टू हैव सम क्वेरीज, क्वेश्चंस, अगर किसी के हो तो जरूर एक बार सर से डिस्कस कर लीजिए। किसी के कोई क्वेरी क्वेश्चंस हैं? एक चीज सर, जैसे मान लीजिए कोई अगर न्यूज़पेपर एडवर्टाइजमेंट कराता है, तो न्यूज़पेपर एडवर्टाइजमेंट मतलब क्या 15 डेज का ही टाइम है कि मतलब जैसे सपोज
नहीं,
अगर
15 डेज 90 डेज तो है ही मैंडेटरी है आज के डेट में, वो तो 15 डेज
क्योंकि
तो
एक एक एडवर्टाइजमेंट 4 जून को होती है और वो 18 जून को जो है उन्होंने कहा कि 18 जून तक अपना क्लेम फाइल कीजिए। 4 जून की एडवर्टाइजमेंट है न्यूज़पेपर की, और उन्होंने केवल इतना ही टाइम दिया 18 जून तक का। तो क्या ये वैलिड है या फिर
नहीं, वो तो ठीक है, उतना ही रहता है, टाइम
तो
पीरियड उतना ही रहता है, लेकिन आप क्लेम देंगे 90 दिन के भीतर, तब तो वो तो एडमिट होगा 100%, उसमें कोई मारामारी नहीं है।
जिस दिन से न्यूज पर एडवर्टाइजमेंट हुई उस दिन से 90 दिन का टाइम है
हाँ
कि हम अपना क्लेम दे सकते हैं।
हाँ
वो भले वो टाइम 18 मतलब 14
वो
दिन
कुछ
का
भी
ही।
लिखा हो उससे कोई फर्क नहीं पड़ता।
अच्छा, तो 90 दिन में वो क्रेडिटर्स वाला वो कंसेप्ट नहीं आया, सीओसी वाला।
ना, वो नहीं है, 90 दिन के भीतर नहीं है।
थैंक यू सर, थैंक यू फॉर। अब कोई और पूछना चाहता है कोई सवाल? और किसी के सवाल नहीं तो सर ने अपना बहुत वैल्यूएबल कीमती समय दिया 1 घंटे, और हमारा टाइम भी ओवर है। तो थैंक यू सर। यस निकिता, आपने बहुत ही अच्छे जजमेंट्स हम लोगों के साथ शेयर किए और बहुत ही आनंद आया आपका सर। नॉलेज ऑफ कोर्स इज वेरी वैल्यूएबल नॉलेज वी गॉट विद टुडे। थैंक्स फॉर योर वेरी वैल्यूएबल टाइम। यस मिस निकिता प्लीज।
It
थैंक
was
यू
my
सर।
pleasure to have all of you with me. We discussed, we basically all of us are professionals. The knowledge sharing is a part of learning for everybody. For me also.
थैंक यू सर, थैंक यू। यस यस निकिता।
I would like to thank Mr. Sanjay Kumar Singh for sharing his valuable knowledge. Also, I would like to thank Dr. Nityanand Singh for providing us this platform through Vidya Vijay Foundation. And at last, I would like to thank everyone for your patience hearing and for joining. Have a great day ahead.
Thank you.
बहुत बहुत धन्यवाद सर, बहुत ही आनंद आया।
Thank you.
बहुत बहुत धन्यवाद।
Thank you so much.
थैंक यू सर।
थैंक यू सर।
फिर कभी आपसे समझ लेंगे।